Hello and welcome. Today we will be discussing the matrix of Shah Bano Judgement, the Muslim Women Protection of Rights on Divorce Act, and the Daniele Latifi Judgement. Let's start with the Shah Bano Judgement. In April 1985, the Supreme Court of India delivered the judgment called Muhammad Ahmad Khan vs. Shah Bano Begum, which turned out to be a rather historic judgment. What happened in the case, you ask? Let's find out. Shah Bano Begum was married to Muhammad Ahmad Khan, an affluent lawyer from Indore, for 40 years before he divorced her due to an inheritance dispute with his other wife and children. And if you ever wondered what they look like, here's one. Or at least that's my imagination of them. Muhammad Ahmad Khan paid Shah Bano Begum a sum of rupees 3,000 during Iddat as the meher amount and rupees 200 per month as maintenance. You may be asking, what is meher and what is iddat? Meher or dar is the consideration amount in a Muslim nikah or marriage which may be paid immediately or may be deferred to divorce or death. And iddat in case of divorce means 3 menstrual cycles of a woman or 3 lunar months, or the birth of a child if the woman is pregnant. For our understanding, let's just say iddat is a period of 3 months. Now let's see what the issue in the case was. Shah Bano Begum was palpably angry about this paltry sum of rupees 3,000 paid to her after 40 years of marriage.
And had Shah Bano Begum lived in North America, she would have sung the following song.
Now that we've seen how angry Shah Bano Begum was, let's see what was the stand of Muhammad Ahmad Khan. Muhammad Ahmad Khan argued that the Muslim Personal Law and Section 127, Clause 3, Subclause B of the Code of Criminal Procedure requires him to pay maintenance and meher only for the iddat period, and no more, hence discharging him of any further liability. So basically, he wanted to say, I will only pay you 3,000 rupees for 3 months. After that, you're on your own, woman. I don't care how you maintain yourself. Now, Shah Bano Begum, as angry as she was, filed for maintenance proceedings under Section 125 of the Code of Criminal Procedure. The main issue which came up before the court in the case was whether payment of meher during the iddat period of 3 months would absolve Muhammad Ahmad Khan from his duty of maintaining Shah Bano Begum after that. Now, an interesting fact is that there were 2 prior judgments of the Supreme Court of India providing that even though meher amount has been paid during the 3-month iddat period, the husband can still be ordered to pay maintenance after that if the woman is unable to maintain herself. So this should have been simple, right? Considering there were 2 prior cases. But this case wasn't. The Supreme Court of India decided to form a larger 5-judge constitutional bench to lay down the law authoritatively. And the Supreme Court said in 3rd para of the judgment.
And is the law so ruthless in its inequality that the mere fact that the husband has paid something, no matter how little, absolves him forever from the duty of paying adequately?
So the Supreme Court saw through this charade of a law and said this is not done. If the Muslim woman is unable to maintain herself after the iddat period, the husband can be ordered to pay maintenance under Section 125 of the Code of Criminal Procedure even beyond the iddat period. So that's great! Hurrah for women empowerment! Oops, spoke too soon. This judgment, as nice and forward as it was, led to a juggernaut of political reactions, where conservative Muslim groups objected to interference in their personal law. They were like, we will pay our divorced women whatever little amount we want for 3 months and get away with it. Don't tell us what to do, Supreme Court. And the reaction of the government was interesting. Even though the Rajiv Gandhi government initially favored and applauded the judgment, they eventually buckled under the pressure of vote bank politics. They did not want to lose the conservative Muslim vote bank. So they enacted a law called Muslim Women Protection of Rights on Divorce Act. Or it should have been called Muslim Women Dissolution of Rights on Divorce Act. Let's see what the act said. Section 3 provided in the clause A for a reasonable and fair provision and maintenance to be made and paid to the wife within the iddat period by the former husband. Clause B provided for maintenance for children, Clause C for the amount of meher, and Clause D for the properties that belong to the wife before or after the marriage. And if you didn't get it by now, why the Shah Bano Judgement provided that the husband will have to pay maintenance even beyond the 3-month iddat period. This law limited the maintenance for Muslim women to the iddat period. So the husband only has to pay during the 3-month period, and after that the woman is on her own. This unfortunate attempt at curtailing the rights of Muslim women continued till 2001, when the final act of this play was written. In 2001, the Supreme Court of India was again faced with the same question in the case of Daniele Latifi versus Union of India, in which the constitutional validity of the above-mentioned law was questioned. And the main question was whether payment of meher during the iddat period is equal to maintenance. This judgment was also delivered by a 5-judge constitutional bench. The Supreme Court reinterpreted the Section 3, Clause 1, which we had just read. The Supreme Court said that when the Act says that reasonable and fair provision and maintenance has to be paid within the iddat period, it means that the husband will definitely pay within the iddat period of 3 months, but it won't just be for the 3 months. It will be a lump sum amount of money which will take care of the woman for the rest of her life. So you pay within the 3 months, but you pay a lump sum amount for the rest of her life. Further, the court said that the differentiation between the meher amount in Clause C and the maintenance in Clause A has been maintained. So let's not confuse those two. You pay maintenance under Clause A as a lump sum amount, and you pay meher under Clause C during the iddat period. This reinterpretation of Section 3, Clause 1 was historic, and the Supreme Court in this manner managed to bridge the gap between rights of divorced Muslim women and a legislation passed under the pressure of vote bank politics. Thus the story, which started with Shah Bano Judgement, found its consummate end in the Daniele Latifi judgment with a slightly wobbly intermission. Coming to a close. If you liked what you learned today, don't forget to like and share our video. Also leave us a comment telling us what legal chapter would you like to learn ASAP next week. Thank you for watching and subscribe.